And so that's running. Let's see, and then we'll make sure that the audio is off on it so we don't have it repeating itself to us 3 seconds after we say it.
All right.
Say now. There we go. I turned that off. All right, now I gotta go back to my Zoom picture. All right, and now admit all. Okay. Good morning, Miss Lamas. Good morning, Miss Wood. Well, I've lost Miss Wood. Maybe she's going to reconnect for us.
You shaved your beard.
Yeah, can you tell?
It's so different. I've never seen you without a beard.
Well, many people have not, but the joke is, and it's only a joke, but every 10 years or so, you need to change your appearance so your creditors can't find you. So it's interesting when I do this, when I grow the beard or when I shave the beard off, people don't recognize me until I speak. And then my voice is apparently the same. Miss Wood, are you there? There you are. Good morning.
I could not figure out what I was doing.
Well, that's fine. We got you back on, and we're ready to go. I've got this streaming on YouTube, so we're in open court. This is cause number DC 1950524 in the matter of the marriage of Tammy Cummings and Tammy Lynn Knott. It's in the 52nd Judicial District Court of Coryell County. Present with the court today is one of the parties, and also Ms. Lamas and Ms. Wood, who are counsel for the petitioner and respondent respectively. This is a hearing on motion to enter order. The court has received the proposed divorce decree submitted by Ms. Lamas, and the court has received a proposed final decree of divorce, order in suit to partition, and final order in suit to dissolve business submitted by Ms. Wood. In addition to that, I have received Ms. Wood's response to the motion to enter by Ms. Lamas and the attached proposed exhibits, 3 of which have been previously admitted as Trial Exhibit 72, Trial Exhibit 39, and Trial Exhibit 40, 2 of which are summaries, one being the proposed Respondent's Exhibit R2 for this hearing is a summary of entries on more than one of the other documents that have been trial exhibits previously admitted, and proposed Exhibit R5 for this hearing is a summary of deposits into the Trial Exhibit 39, which is business account 301. I think I've stated all that correctly.
And 40, Your Honor. The last summary puts in some money went into 301, some money went into 348. So it's both.
Okay, so it is a I'm sorry, it's a summary then of both 301 and 348
Yes.
business records. Okay, so but anyway, these two exhibits were not previously submitted to the court, and so there is a motion on today's hearing, which is titled Respondents Exhibit List and Motion to Enter. So I assume it's a motion to enter the two summary exhibits.
Yes, Your Honor. And it's
Is
demonstrative
there-
aid. I'm just offering them as demonstrative aids because what they do is they take those exhibits and just give the court page numbers, because I can promise you it's very, very lengthy to go through 300 pages of records and find each one of those entries.
Yes, I tried to do that previously and had great difficulty. Prior to the ruling coming out. So, but these summaries were not offered during trial. And so the question is whether or not there's objection to them at this time.
Well, for one thing,
so Ms. Long.
I mean, for one thing, I mean, my understanding at a hearing to enter order, the purpose is, does the order conform to the ruling of the court? Okay, we're not here to relitigate matters, and I feel like Ms. Wood is wanting to relitigate the ruling because they're not happy with the ruling, and I'm not prepared to do that today. I'm here to get the order entered, and so I'm going to object. They were not offered as trial exhibits. I received these yesterday by FedEx. I think I received them the day before by email. I mean, a 315-page response. I have not had time to go through these. I don't know if they're accurate or not. I don't see how they're relevant to deciding whether or not the order that I have prepared conforms to your ruling. I do not believe they are relevant.
Okay, and you object to the timeliness and all the others. So your objection's noted for the record. And Ms. Wood, you wish to respond?
Yes, thank you, Your Honor. The reason that this has all happened so late is that when we had our conference call, our spontaneous conference call about the sale and getting the documents done to close on the house, some of these other issues were raised, that there was some conflicts in the language in the ruling, which exists now in the decree. And then there was some talk, I did talk about the mortgage and the equitable reimbursement. And you said that we would have another opportunity to argue that again. I was anticipating that we would do that before we had the motion to enter, and I did try several times to get a copy of the decree as well, but Ms. Lamas was in court. And so by the time I got that and we set the motion to enter, we had not had this other opportunity to argue. So she is correct that I am trying to argue some of the issues. One is as a matter of law, on the equitable reimbursements and how they, separate as to the partition, how they are separate from the other transactions that the court referenced in the letter ruling. And secondly, we all agreed in that last conference that there was an order that said everybody pays everybody keeps what's in their possession, and she was awarded her Jeep, and everybody pays the encumbrance on the debt on their property awarded to them. But then you awarded the $60,000 note to Ms. Cummings, and I don't know whether there was a confusion as to which Jeep was the collateral. But the collateral for the $60,000 note is the Airstream, which was awarded to Ms. Cummings. But my client's Jeep Wrangler, which she testified she'd always even made the payments out of her separate account. So, but there is obviously there's going to be a conflict and nobody's going to be able to enforce that one way or the other. So that needs to be resolved, even if the court has decided now that we're not going to have further arguments. And then the order,
Go ahead.
the order that I sent goes through and just basically, I used her decree and fleshed out some other things that were vague. So when are we going to pay this money? How are we going to pay this money? Which of course, I'm asking that the court let the appellate timetable run before we disperse the only asset left that we can put hands on. So that is what the decree does.
Thank you. First off, because of the unusual nature of the partition being involved in a divorce, and I recognize that that could come up under any divorce if the parties had been joint tenants prior to their marriage. But because of that unusual nature, it rarely comes up in divorces. And I think it's rare enough that in my 30 plus years of hearing cases, this is the first time it's come up with me. That doesn't mean it hasn't come up other places, but I haven't found any other case law where it's come up in a divorce partition combination suit. We were discussing it in the prior conference call, whether there needed to be a severance and various other issues that were just technical issues so that the sale of the property could proceed. And those issues have been resolved in regard to those matters. But we did say other matters would be taken up later. And I did point out at that prior conference call that the court's intention was to have the net proceeds of the partition sale put in the registry of the court, and that arguments in regard to equitable reimbursement would be entertained at a later point. That's all, as I heard it, that's what I meant to say and what I think I said in our prior hearings in this matter. But the parties were anxious to get the property sold at the highest possible price, and there were some issues as to what time of year that would come about, and as it turns out, it sold for what I believe was a market price, and the market price was, in my opinion, pretty good at this point, but who knows? The issue, though, for me today is whether or not this motion for to enter the summaries as exhibits is in fact, or in essence, a motion to reopen and enter additional exhibits. And I understand the argument that they're merely demonstrative and help extract the information out of the record so that it's usable to the court. But they perhaps should have been offered previously during the actual trial. Either way, the court will have to consider that. I'm not going to rule on that today because this is simply a hearing to enter an order. And the hearing was filed by Ms. Lamas because she had prepared the order and sent it. And then you prepared a version of the order that you believe is more appropriate, but clearly does not follow the letter ruling that I sent out because it doesn't discuss reimbursement. Matter of fact, the letter ruling denied reimbursement, and this proposed order sets up a system of reimbursement. So this is a question of whether we can, first off, reopen and introduce additional exhibits, which are summaries. Secondly, when would we hold a hearing for the arguments on reimbursement and that sort of thing? I agree with Ms. Lamas and her objection that that was not what was set for today. And since these documents came, you will find this entertaining, and it's not intended to be entertaining, it's just a fact. I have been very busy this week, I'm not always very, very busy. And frankly, that's why I retired, is so I would not always be very, very busy. And I know you guys work full time and are very busy, and I'm happy for you, and I hope you enjoy it. And I think you'll enjoy retirement when you get there. But this week I had agreed to act as a totally different role of a different kind of judge. I'd agreed to be an election judge on the election on November the 2nd, having no idea what that consisted of when I entered into that agreement with the people at the elections office. And it's very interesting. It's quite educational. I think it's a great thing. People ought to know what goes on in elections and how they work, and the safeguards that are in place in Texas under our previous laws and even under our existing laws. And this was a good election to learn on because it consisted of predominantly the constitutional amendments that were proposed. And I didn't have a lot of controversy here. There were some city and school board election information in some of the precincts. McLennan County, where I volunteered because that's where I live, has voting centers as opposed to separate. We have separate precincts, but we vote at voting centers. So there's several scattered across the county for the convenience of the citizens. But any center will accept a voter to register that's registered to come in and vote in any precinct in the county, which creates an interesting computer situation and requires a separate secure network to communicate and a number of things like that. I didn't realize that election judges set up the furniture, which isn't bad. I've set up furniture at a lot of things in my life, but that was one of the things I got to do. First off, they pick up the materials from the elections office, and you do that on Sunday. So I did that. And then you safeguard the materials. And then on Monday, you go out to the location, which is across the county from where I live, and as in a remote corner of the county. And you go over there and you set up the equipment. You cut the seals on the equipment, and you set up all the machines, and you hook the machines together, and you what they call daisy chain them, all kinds of nonsense. Wonderful stuff. You hook them to the electronic voting machine, which every county has different kinds of machinery. And but ours has a pretty good system, but it's not new. It's goes way back. People sit down at it and think it's a touch screen, and it's not. It's operated by the rotary dial at the bottom and a button, which is an interesting system put out by Hart. And so you have to train voters on that. Anyway, you set it all up on Monday. You run a test on it to make sure it's working. Then you take and unconnect the machines. You reseal them so nobody can tamper with them. You carry the controller back to your house and keep it under lock and key. And then you go back out in time to open the polls at 7 a.m. on Tuesday, which from where I live means you wake up at 4:30. And so you're getting the idea of, I didn't know what I was doing when I volunteered, right?
Right.
The old Army saying, never volunteer, take one step back. Anyway, so I did that. And then if you're the election judge, it's appropriate for you to stay there during the election.
Like all night, right? Don't you stay all night?
No. You go out and set it up the first day, break it down, reseal it so you don't have to stay with it.
No, but I mean, like you have to stay from 7 to 7 and
yes.
then until all the things are tallied. And
well, you stay from when you get there at 6 a.m. and unlock the building, because the people that have let you use the building aren't even going to come there. Right. At that time of day. They give you their keys and say, please don't bother us. And you go and unlock the building, you let it
on y'all's end too.
You're freezing up, Judge.
I reviewed this too, for what that's worth. So I'm going to go ahead and simply recess this hearing. At this point, I'm not going to enter a ruling. We'll reset it for another time after you've had an opportunity to review all of this and formulate your objections if you have additional exceptions, Ms. Lamas. And I'll take that into consideration then. And at some point, we'll set a hearing to distribute the proceeds.
Well, and that's the problem.
Does that make sense?
Because I need to get those proceeds distributed because the court ordered my client to pay that $60,000 note that's secured by Ms. Knott's Jeep that she was awarded. And that note was actually due at the end of September, or was due a long time ago. It was extended through the end of September. Then they gave one more extension through the end of October, and they're wanting their money. And she's going to need to be able to pay that loan off with those sales proceeds. And I mean, we're all in limbo until we can get this resolved. And that is a problem.
I understand. And I will accept a motion to pay off that note and debit that against the proceeds that may be going to Ms. Cummings. Now, I understand there is a motion to distribute the proceeds differently, and I'm not sure that the motion that Ms. Wood has filed or that is seeking the distribution that Ms. Wood is seeking on behalf of Ms. Knott would leave $60,000 in that account for Ms. Cummings. I haven't done the math. But at any rate, I'll let you all discuss that amongst yourselves. I will entertain a motion to get that note paid out of the proceeds that are held in the registry of the court, and then determine how the distribution will go further at a later time, if that's possible.
I mean,
And we can set that up on a telephone conference motion or whatever and make a ruling on it. And I can enter an order getting those proceeds distributed out and paid directly to the bank, but credited against the debt that the court has. You say I awarded the debt, I actually charged the debt rather than awarding it. But anyway, I did award that debt to Ms. Cummings.
I mean, and the problem is, I mean, at some point, this divorce needs to come to an end. It needs to be concluded.
I agree, and I can't see how we're going to end it with it in less than 30
I don't
days.
either, because it doesn't appear to me that Ms. Knott wants it to end. And I mean, if it is appearing to me that Ms. Knott is wanting to go in and relitigate something that we've already spent a bunch of time litigating. And so now, and one of the complaints that Ms. Wood has made is the amount of attorney's fees. But now I'm going to have to sit here and charge my client to go through these 315 pages of documents that she's filed yet again to do these summaries. And I'm just very frustrated by this, because I want this over, my client wants it over, and we're prolonging it. And now we're having to incur more attorney's fees to go back and revisit all these summaries that have just appeared within 2 days.
First off, there's a motion to reopen in essence and to enter the summaries. You've objected to that, and I understand your objection. I'm taking that under advisement because this has hit me, like you say, just overnight, just like it hit you overnight, okay? I will recess this hearing and make a ruling on those motions, either early next week, or I can probably get you back online Tuesday of next week, something to that effect. And we can do it by telephone rather than by Zoom hearing if you would prefer.
I would not, Your Honor, because there was some discrepancies as to what you said last time in the phone, and part of it I think was because Ms. Lamas was having difficulty hearing you on the telephone, but there were some.
Yes, we had a bad connection on the
Yes.
phone that day too.
Yes, and so I would prefer that we do Zoom because of the,
That's fine. I'll go ahead and set it up for a Zoom hearing if that's what you prefer rather than telephone. And why don't you give me an available time early next week for us to reconvene this hearing and entertain those motions, and then I can make an order. But I want to do some research on the legal aspects of introducing these summaries at this late date.
and well, Your Honor, I just want to say, I mean, of course you should do that. But if you'll recall at the hearing, like on day 4 or 5 or wherever we were at the end there, I made a comment that we have these bank statements, and I said, I'm not going to go through each one, but I could in argument. So that's fine. And now everybody can look at it so that you'll be quick to follow. But there's nothing to prohibit me in my when we re-argue this, or had we had oral arguments that day instead of written arguments, there's nothing to preclude me from going. And you'll see, Judge, on page so-and-so, this was done. And you'll see, Judge, on page so-and-so, this was done. And I said, and I don't say
I understand that, and I'll Ms. Wood, I understand that.
Okay.
And I ask you to submit written oral arguments, or, not oral, but I ask you to submit written arguments. And you did go through your arguments and you made those arguments. You're now asking to essentially supplement those arguments with these summaries. And I'll consider that. But I'm not going to rule on any of that today because I don't think it's fair to Ms. Lamas, because this has just come up today. So let's look at a time when we can hear this. What does y'all calendar look like? And
I have depositions on Monday and a hearing on Tuesday. Like I have to go to Hays County and physically be there on Tuesday.
Okay.
But the rest of the week I'm open.
Wednesday's out for me. Thursday's Veterans Day. Friday, the morning is the only time I have. Does that work for you, Ms. Lamas? Friday morning, the 12th?
No, I have to be, well, maybe. Right now I have a hearing scheduled in Milam County, but I think that's going away. So I tentatively could do it, but I do have a hearing in the Bell County Courthouse that starts at 1:30. So I absolutely have to be done with this in time. I have
to be in Dallas that afternoon, so that's fine. We could do it in the morning if that hearing goes away. So let's tentatively set up a Zoom hearing for 9 o'clock on the 12th as a continuation of this hearing and to entertain these additional motions that have been filed, okay, and to get rulings on that as to whether or not how the court will consider the summaries, okay?
Okay, thank you, Judge.
And if that doesn't work, if your hearing doesn't go away, Ms. Lamas, can we have an alternate date the following week?
I really do think it's going to go away because the other lawyer is in Houston, Pearland.
So you're comfortable with setting it on the 12th?
I really am comfortable with setting it. I don't know that it's been passed yet, but they've already emailed me saying we're happy to agree to your continuance, and we'll look at reset. Tracy's already looking at reset dates. It just hasn't been technically passed, but I am 99.9% sure that it's going away.
Okay. Well, then I'll set this up at 9 o'clock on the 12th, and we will reconvene at that time. Does that work for you, Jeanette, my reporter?
I was supposed to be off, but is it going to take a couple of hours?
I don't think it'll take that long. I'm thinking we're looking at 30 minutes
because
I'm going to be researching the law on this. But maybe when I say 30 minutes, that always means an hour. I'm sorry. Right. All right. Okay, so we'll set it up for 9 o'clock that morning. And we'll recess then. I don't think there's anything else we need to take up now. I just need to do some legal research and entertain whether or not I'm going to reconsider my ruling in regard to reimbursement. So I'll be entertaining those things in my head, looking through this and seeing what I think is appropriate. I appreciate the hard work you've both done on this. And I recognize that it's been challenging in many aspects. But thank you very much for that. Anything else?
No, sir.
Thank you very much. We're off record then and on the way. And I'm sorry to bore you with all of that stuff about an election judge. But if any of you are thinking about volunteering to be an election judge, it's a noble thing and a wonderful thing to do. But I would caution you in regard to knowing exactly what it is. I didn't have to tear down the tables. They said, leave them up. They had a wedding coming up. Like,
Oh, that's good. That's good.
that's nice, isn't it? Yes.
Yeah.
The
Did you
people
have
that
to
were
do-
with me were thrilled. Did I have to what?
Did you have to do it all alone?
No, I had
Oh.
one other person help me. So
Okay.
there's my 75-year-old body. My wife came along, bless her heart. And then another 65-year-old lady came in, and the three of us set it all up, and it's just a
Yeah.
joy. I want you to, and 75 people came and voted at our polling place that day.
Well,
The longest, which, they have, I'm glad they did, and it was wonderful. And I got to see people I haven't seen in years. I got to see, there's some folks down in Mark that, I knew way back. Did you know Senator Murray Watson, state senator, years and years ago?
I think, I mean, like not where we would sit down and chat, not in peer, but I know who
Yeah.
you're talking about.
Well, he was from Mart, and his wife is still there. They run the only thriving business in Mart, in my opinion. It's a feed store. And they've been there. The store's been there over 100 years. It's the longest single operating Purina food dealer in the country.
Yeah.
So they've been operating for over 100 years there, and everything else in Mart is, if you want to rent a building, it's a good place to find an empty building.
The only person that I knew well from Mart were
we're off
Felix.
record, Jean Ann. You can go about your business.